These are 50 doctrines on Philippine corporation law that can help us navigate this concept. First, Separate Juridical Personality Doctrine. In this doctrine, a corporation has a distinct and separate legal personality from its shareholders, directors, and officers. Doctrine of Piercing the Corporate Veil. In this doctrine, the corporate veil may be pierced to hold shareholders or directors personally liable if the corporation is used to commit fraud, evade the law, or circumvent contractual obligations. Business Judgment Rule. In this doctrine, directors and officers are not liable for decisions made in good faith within their authority and with reasonable care, even if the decisions turn out to be unwise or detrimental to the corporation. Doctrine of ultra vires. These are acts of a corporation that are beyond its powers as provided in its articles of incorporation or by law are ultra vires and therefore void or voidable. Doctrine of corporate opportunity. In this doctrine, directors and officers must not exploit business opportunities that belong to the corporation for their personal gain. Doctrine of limited liability. Shareholders are liable only to the extent of their capital contributions and are generally not liable for the debts of the corporation. Doctrine of de facto corporation. In this case, a corporation that has made a good faith attempt to comply with incorporation requirements may still be recognized as a corporation in some situations, even if there were defects in its formation. Doctrine of succession. This means a corporation continues to exist beyond the lives of its shareholders or directors and only ceases upon formal dissolution. Doctrine of apparent authority. In this doctrine, a corporation may be bound by the acts of its officers or agents when third parties reasonably believe that those individuals have the authority to act on behalf of the corporation. Doctrine of estoppel. A party may be precluded from denying the existence of a corporation if they have treated it as a corporation and gained benefits from it. Trust fund doctrine. In this doctrine, the capital stock, properties, and assets of a corporation are considered a trust fund for the payment of corporate debts. Doctrine of corporate democracy. This means shareholders have the right to vote on certain corporate matters, reflecting the democratic nature of corporate governance. Doctrine of corporate responsibility. Corporations have certain legal, ethical, and social responsibilities toward their stakeholders, including employees, customers, and the community. Doctrine of centralized management. This means that management of the corporation is vested in the board of directors, and shareholders cannot directly manage corporate affairs unless specifically allowed by law. Doctrine of merger and consolidation. This happens when two or more corporations merge. The surviving corporation assumes the rights, properties, and liabilities of the dissolved corporations. Doctrine of corporate rehabilitation. In a financially distressed corporation, this may undergo rehabilitation to restore its viability while staying creditor claims temporarily. Doctrine of right of first refusal. This means shareholders may have the right to purchase shares of other shareholders before they are offered to third parties. Doctrine of preemptive rights. This means that existing shareholders have the right to purchase newly issued shares before they are offered to the public to maintain their proportionate ownership. Doctrine of corporate disregard. In certain circumstances, courts may disregard the separate personality of a corporation when it is used to perpetrate fraud or circumvent the law. Doctrine of voting trust. Shareholders may create a voting trust, transferring their voting rights to a trustee to vote as a block, often to stabilize corporate control. Doctrine of cumulative voting. In this instance, shareholders may distribute their votes among multiple candidates for the board of directors, allowing minority shareholders to elect directors. Doctrine of deadlock. This happens when directors are evenly divided and cannot agree on decisions. Thus, shareholders may intervene or the court may appoint a provisional director. Doctrine of derivative suit. In this instance, shareholders may file a lawsuit on behalf of the corporation to enforce or defend its rights when the corporation's management fails to do so. Doctrine of closely held corporation. This means that closely held corporations may operate under less stringent rules compared to publicly held corporations, particularly regarding shareholder agreements and governance. Doctrine of insider trading. This means that corporate insiders who trade securities based on material non-public information may be held liable for insider trading. Doctrine of dissenting shareholder appraisal right. Shareholders who dissent from certain corporate actions may demand that the corporation buy back their shares at fair value. Doctrine of quasi-reorganization. A financially distressed corporation may reorganize its capital structure without going through formal bankruptcy procedures. Doctrine of corporate control. The control of the corporation typically lies with the majority shareholders, but minority shareholders have certain protections against abuses of this control. Doctrine of corporate liquidation. Upon dissolution, a corporation's assets are liquidated and proceeds are distributed to creditors and shareholders according to their priorities. Doctrine of anti-dummy law. This law prohibits the use of dummies or nominees to circumvent nationality restrictions in certain industries, ensuring compliance with the Constitution and other relevant laws. Doctrine of capital maintenance. Corporations must maintain sufficient capital to meet their obligations and are generally prohibited from returning capital to shareholders if it would render the corporation insolvent. Doctrine of minority protection. Minority shareholders are protected against abuses by the majority, particularly in transactions that are unfairly prejudicial to them. Doctrine of corporate governance. Corporations must adhere to principles of good corporate governance, including transparency, accountability, and fairness in managing corporate affairs. Doctrine of Financial Assistance. A corporation is generally prohibited from providing financial assistance for the purchase of its own shares, subject to certain exceptions. Doctrine of Subsidiary Liability. A parent company may be held liable for the obligations of its subsidiary if there is sufficient control, and the subsidiary is a mere instrumentality of the parent. Doctrine of Non-Impairment of Contracts. The government cannot pass laws that substantially impair the obligations of contracts, including those involving corporations. Doctrine of Fraudulent Conveyance. Transfers of corporate assets intended to defraud creditors may be set aside or invalidated. Doctrine of Corporate Disclosure. This means corporations, particularly publicly held ones, are required to disclose material information to shareholders and the public to ensure informed decision-making. Doctrine of Corporate Governance Codes. This means corporations must comply with corporate governance codes issued by regulatory bodies such as the SEC to promote ethical business practices. Doctrine of Management Prerogative. The Board of Directors has the authority to make decisions concerning corporate management, subject to limitations imposed by law, the Articles of Incorporation, and the bylaws. Doctrine of Par Value. Shares issued by a corporation must not be sold at a price lower than their par value unless authorized by the corporation's charter. Doctrine of Stockholder Meetings. Stockholders have the right to attend meetings, vote on certain matters, and be informed of corporate developments. Doctrine of Notice and Quorum. Proper notice and quorum requirements must be met for corporate meetings to be valid and binding. Doctrine of Preferred Shares. Preferred shareholders have priority over common shareholders in dividends and liquidation, but typically do not have voting rights unless otherwise provided. Doctrine of Proxy Voting. Shareholders may vote in corporate meetings through proxies who are authorized to vote on their behalf. Doctrine of Cumulative Dividends. Preferred shareholders may be entitled to cumulative dividends, meaning unpaid dividends accumulate and must be paid out before any dividends are paid to common shareholders. Doctrine of Staggered Terms. Directors may have staggered terms to ensure continuity in the board and prevent complete turnover in any single election. Doctrine of Double Taxation. Corporations may be subject to double taxation where the corporation pays taxes on its income and the shareholders pay taxes on dividends received. Doctrine of Corporate Resolutions. Corporate actions, particularly those involving significant decisions, must be formalized through board or shareholder resolutions. And the last, Doctrine of Corporate By-Laws. The internal rules governing a corporation's operations are established in the bylaws, which must be consistent with the Articles of Incorporation and applicable law. All right, I hope those doctrines will help you. If you like this video, don't forget to like, share, and subscribe. Thank you for listening.